Good morning. Today is Monday, March 4th, 2024. This is the Appeals Hearing Board meeting. I'll start with a roll call. Board Member Chang,
Here.
Board Member Milich,
Here.
and Board Member Glanzer.
Here.
Okay, let the record reflect that 2 board members are here and 1 alternate.
I will call the meeting to order. And the very first thing, I would like the city attorney or somebody to read how to participate in this meeting.
Yes, I'll go ahead and do that.
Thank you.
For information participating in this meeting and providing public comment, including remotely by Zoom or telephone, is on this meeting's agenda, which is online at isearchmonterey.org. Remote commenters will be muted until it is their turn to speak, and a timer will be shown on the screen. If you are connected on Zoom, the timer is accurate with no delay. In the chambers, we ask that attendees keep their phones and devices muted to prevent audio interference with the meeting. And as always, thank you for participating in your city's government.
Thank you. The next item in business would be a consent agenda. We have no items on the consent agenda. The general public may make comments on any item within the jurisdiction of this board that is not calendared. Please keep your comments to 3 minutes or less. Is there anybody who would like to address the board with a general comment on an item not on the agenda? Is there anybody on the phone?
No one at this time.
Thank you. Okay, we'll then proceed to a public hearing. And in this hearing, the item that we'll deal with today is one item. That is appeal by Monterey Plaza Hotel and Spa, 400 Cannery Row, Monterey, California, 9394 of Zero of Finance Director's Transient Occupancy Tax Audit Deficiency Finding. Not a project under SEQA Article 20, Section 15, 378, and under General Rule Article 5, Section 5, 15061. I would like to, at this time, invite any of our members here on the board, on the panel, to disclose any ex-parte contacts you may have had regarding this item with any members of the public or with any members of the appellant. Is there anything to disclose?
No ex parte contacts.
Nothing to disclose.
And I have nothing to disclose either. At this time, the city attorney to make any disclosures, please.
Yes, thank you. I'm Christine Davy, the city attorney. Assistant City Attorney Karen Salama is representing the finance department in this matter, and I'll be advising the appeals hearing board. We have maintained a due process screen to ensure fairness of the hearing proceedings. In other words, I've not discussed this matter with staff or with Ms. Salama, and we've maintained that separation to make sure the process is fair.
Thank you. Well, how we'll handle this procedure or this hearing is that staff will make a presentation. Then it will be followed by the appellant's presentation and public comments. And then each party will be given a chance to rebut what the other parties have brought forward. Then after that, we'll bring it back to the board and we'll have a discussion of the board on the matter, and then we'll hopefully take a vote. With that in mind, staff presentation. Karen?
I'm gonna pull up the PowerPoint. Hi, Joe. Okay. So, good morning, board members. As you know, I'm Karen Sullivan, the Assistant City Attorney representing the Finance Department. In this case, I will be presenting the staff presentation along with the city's consultant, HDL companies, specifically Carrie Calloway, the auditor, who worked on this matter along with other people. So let me start off. We're going to cover briefly the audit, purpose, process, and then the specifics of the case with respect to the Monterey Plaza and the calculations. And obviously the latter part of that will be handled by Carrie. I'm not going to attempt to explain the math or anything like that. So in terms of the TOT, so that's the transient occupancy tax that the city's voters enacted. And so this is approved by the voters, and it's in the city code in chapter 35. And so just as general background, for the privilege of occupancy in any visitor accommodation facility, what we would commonly think of as a hotel or a motel, something like that, each transient, that's the guest in the hotel, is subject to a tax, which is now at 12%. That was raised in the election in 2020 from 10%. So such tax constitutes a debt owed by the visitor to the city, which is extinguished only by payment of the operator. So the hotel is responsible for collecting the tax and remitting that, sending it to the city. And the code specifically provides that the transient shall pay the tax to the operator of the hotel at the time rent is paid. So whenever they pay for their reservation or they walk in with cash, that's when the TOT is due. And if it's paid in installments, a proportionate share of the tax shall be paid with each installment. So then a tricky part then becomes, well, the tax is applied to rent. What is rent? And so the definition of the rent is important. And that's the consideration charged to the transient, whether or not received, for the occupancy of space in the hotel. And it can be, received in money, goods, rewards points, whatever you want to think of it, anything of value. And then rent includes charges for amenities, including but not limited to movie, DVD fees, minibar fees, telephone fees, parking fees, resort fees, charges for rollaway beds, cribs, pet fees, and internet fees, in addition to online booking fees and charges. So that definition is in section 35-10 of the city code and was also adopted by the voters in the 2020 election. But even before then, rent was defined as including charges for amenities. We added specifics after that. Now, the code also requires record keeping and gives us the right to audit. So it shall be the duty of every hotel operator liable for TOT collection to keep and preserve for a period of 4 years all records as may be necessary for the city to determine the amount of tax due. And then we can go back, the finance director and their authorized agents. In this case, the finance director authorized HDL companies to act as the city's auditor. They go out, they get the records pursuant to this section and make sure that the TOT that was actually sent to the city is correct. If it's not correct and there's what's called a deficiency, then we come to this situation where we send out a notice to the hotel and say, here are the reasons why in the audit we found the amount you sent to the city in TOT doesn't match your financial records. And they have a right to appeal that. So, Carrie, do you want to take over for a bit?
So my name is Carrie Calloway and I am the audit manager for HDL. So I'm just going to kind of go over the purpose of the audit and like the audit process and then the findings and things. So the whole purpose of a hotel audit is to confirm that all hotels in the city are properly reporting and calculating that transient occupancy tax. And if necessary, correcting any errors or omissions that could have been made. Audits ensure that all hotels are on equal footing and that the system of taxation enacted by the citizens of Monterey is being properly followed by the hotels. On a practical level, the audit's objective is to determine if the hotel's financial records support the filings for their TOT reports and remittances monthly. And here's kind of just a quick overview of our audit process. So in month one, that's our preparation for the audit. So we are sending the audit notice to the hotel, and we give them 3 weeks to gather all of the initial documents. And then in month two, that's where the auditor is going to meet virtually with the hotel. And at that point, the auditor has kind of looked at the records. If they have any questions or need additional information after they've reviewed what the hotel has sent over, then they can kind of go over that in the month two. And then in month three is where our auditor is preparing the report and writing the report, doing the work papers. And then we send the audit report to the hotel. And we try to finish all of that within a 90-day span. And then in month four, that's our finalization process where the city is considering and ratifying our findings. Findings letters are sent to the hotel for payment and or clearance. So just to kind of go a little bit more in depth on the process. So the first thing we're doing is we're sending the audit announcement letter. This was sent to Monterey Plaza Hotel and Spa on March the 6th, and it's a notification letter from HCL regarding the compliance audit. And then it's just a notification stating that the hotel's records will be audited for the periods of January of 2020 to January of 2023. And then it also gives them the week of which that audit will take place virtually. Next, after we've reviewed all the documents, we have sent the information over to the city for them to ratify our findings. That's when we then send out the audit findings letter for Monterey Plaza. This was sent to them on December the 7th. Was the findings letter and the invoice were mailed and emailed to the hotel, and the invoice showed the $84,818.33, including the 10% penalty if paid before December the 22nd. The hotel was also notified in that letter to communicate with HDL and provide more backup documentation if they disagree with our findings. So we give them ample time to come back to us and say, we found additional documents that we weren't able to provide during the audit, things of that nature. So they have time to provide additional documents. And then HDL advises the city that the hotel was very cooperative during the dispute and provided additional documents and information. And they actually did that on December the 15th is when they provided those additional documents to us. Once we received those documents and we reviewed everything on January the 16th of 2024, we were able to revise the audit findings letter and send a new invoice totaling $56,182.41. Again, that includes the penalty if paid before January the 30th, 2024, and that was mailed and emailed. And then on January the 22nd, the city of Monterey received a check from Monterey Plaza Hotel and Spa in the amount of $56,182.41, along with their request to appeal the findings. So just to kind of go into our calculations, so per the city of Monterey code, the following items were included in gross receipts. So they had some communications, which falls into the internet, phone. They had some cancellation fees. They also had resort fees and some parking fees. Now, those parking fees did not become taxable until January of 2022. Then after we had all of those gross receipts together, we take a deduction for any exemptions that they may have. So they may have some long-term exemptions or government exemptions. So that total revenue was then compared to the amount that they reported to the city of Monterey on their TOT returns. Then the difference of that calculation was the additional revenue that the hotel will owe. And here's an example of the calculations for 2020. So you can see that we took the P&L revenue, which should be all of the room revenue. We added in those communications, the revenue from that, the cancellation revenue. They also had some revenue for resort fees and a minibar fee. So that gave us a total of the 13,524,619.25. They had no exemptions for that year. So again, the total was just the 13,500. And then as you can see, what they reported to the city of Monterey was 13,285,850. So that brought us to a difference of 238,769.25. Again, that's a yearly difference. So then we took that yearly difference and divided it out monthly just so we could calculate the penalties correctly.
Okay, so then, brings us to today. We sent out the notice for the 56,182. And the hotel properly appealed, and so we have the hearing today. So formal rules of evidence don't apply, and the city has the burden of proof, and we're happy to answer any questions you may have.
Is there typically a standard of review applied by this board before that burden?
It would be a preponderance of the evidence, which is a little bit, if you're looking at the scales of justice, everyone says it's just a little bit higher.
More
than
likely
50.
than not.
Yes.
Okay.
I do. Could you put 3510 up on the screen again, please?
Yes. There we go.
Okay, I noticed an anomaly apparently. The staff report indicates a quotation from 3510. And I'm probably missing it, but maybe you can find it for me.
Board Member Milich, are you referring to on item page 3, packet page 6? It talks about the definition of occupancy in section 3510.
The one that mentions or the right to the use of possession.
So section 35-10 is the definition section. So quoted on this slide right here is the definition of rent. 35-10 also includes other definitions, including the definition of occupancy. And so the definition of occupancy is quoted in this agenda report, and it is the use or possession or the right to the use or possession of any room or portion thereof in any visitor accommodation facility for dwelling, lodging, or sleeping purposes.
That's what I'm referring to. And I look at 3510 and you have the underlined part or the right to the use or possession. And I don't see that in 3510.
So,
Where did that come from?
Alicia, can we switch to this for a second? It's like that. Well, you know what? I could do it on here because it's available online. Let me escape. Just accept cookies right now. Okay, so in section 35-10, which hopefully will load momentarily. It's working on it. Okay, so there's section 35-10, and it includes a number of definitions. So I'm gonna kind of scroll here and highlight.
Okay.
There's occupancy, And then if you scroll down a bit, there is the definition of rent that we had on the slide. So they're both included along with, for example, operator or finance director.
When was that definition of occupancy passed? When was that enacted? You know? And
I do not believe it was changed in 2020. I believe it predates that. I do not believe the definition of occupancy has changed. I litigated a case in the Superior Court regarding that provision well before COVID.
was when the transit occupancy tax was increased by a vote of the public, did the public also vote on adopting or sanctioning this section? Do you know?
So I know they did vote on the definition of rent, and perhaps the city attorney.
I can try to pull it up on my computer. If you just have a few minutes, yeah.
Okay.
Mhm.
Um, when and did the city start collecting taxes for the right of possession?
So the use or possession, I believe, has been in the TOT ordinance since before 2020. Now, Ms. Davi is confirming that right now.
That's important for me to know.
Mhm. Yes, that's my understanding. We'll get you a definitive answer.
Well, I apologize for the wait, but I want to make sure that we know, get all the information that we need. Thank you for being patient. I'm interested in when we started charging for the right to possession as a part of a transit occupancy tax. Did that start in 2020? Does it predate 2020? And if so, how far back do we go? All this is very important to me as far as deciding the degree of proof. That it's not something that was just pulled out of the thin air.
No, regardless, this definition of occupancy. Well, I'll let Ms. Davi.
How long have we been collecting this tax on the right to possession or on liquidated damages?
So do you mean cancellation fees?
Yeah.
So from a practice, obviously, our interpretation is that the right to use language has been in there since before 2020. We haven't done an audit in quite a number of years. Whether it was being properly implemented, I don't know. But we have advised that language entitled the city to TOT on
I
cancellation fees.
understand the position. I'm just trying to find out when have we found out that, yes, we can get this revenue?
So
Was it after we referred it to HLD or was it before that?
No, before.
I'm looking right now at resolution 21-121, which added a measure to the ballot to ask the voters of the city of Monterey to approve an increase in the transient occupancy tax and to expand the application of the tax to online travel companies, with 16% of the revenue to still go to the neighborhood and community improvement program and 84% for unrestricted general purposes. It says here that in November of 1998 general election, Measure B was approved by the voters, and that's when we started the neighborhood improvement program. And I thought it would say
Is
here,
3510 in existence at that time.
yes,
So
I'm looking in the history here to see if it'll give me more. Mhm.
bearing in mind the city has the burden of proof.
Right.
That's what happens when
You
you
know,
put a
so-
lawyer on the board.
No, I apologize. The ordinance that was adopted and passed by the voters, it really did codify the pre-existing and then increased the amount of the
Mhm.
fee.
Okay,
So you're wondering if the word
right to possession,
right to possession was in
Existing.
this legislation or before this legislation?
we, either one, both actually.
Okay, so
Was it before this legislation? And if it was, then did this legislation incorporate it?
okay, let me check.
Stephen, what you're reading in right to possession, you're just interpreting that as occupancy. You're talking about. right to possession.
Okay, so I'm sorry, in the definitions, we did not change the definition of occupancy.
Okay, so that predated. the-
It predated it.
Right.
Yeah.
And rent was updated. That definition was updated.
Okay,
So the definition of occupancy was consistent the entire period of the audit,
That's what-
predating the audit. Yeah,
and it predated,
yes.
Mhm.
okay, the increase that was submitted to the voters.
The definition of occupancy predated it. Yes.
Okay, all right,
Mhm,
thank you.
mhm. Any other questions?
I have just a quick one.
Yeah, go ahead.
This is really quick. Has the city used HDL before? Or is this the first time that they've been used?
I'm gonna let the finance director answer that question.
What was your question again?
I asked whether this is the first time HDL has done this for the city or whether they've been used in the past.
We actually. I'm sorry, that's an alarm. We actually use HDL for other services. We use them for our sales tax. And I forgot for what. We use them for a couple of other things, but this is the first time we've used them for the TOT audits.
Okay, thank you.
And Corinne, just to clarify the city's position here, it's that a cancellation fee is going to be read into use or possession within the occupancy clause and therefore is rent, just to make it real clear. That's what you guys are arguing?
Yes.
Okay. Does the appellant have any questions? Questions,
Or-
not testimony, you'll get your turn, but you question anything that's been presented.
No.
Okay. All right, then we'll proceed to the appellant. Would you like to make a presentation? Please step forward to identify yourself and let her rip.
See if we can get this up. All right, good morning, all. Good morning, board, Ms. Davi, staff. My name's Chris Summers. I'm the managing director at the Monterey Plaza Hotel and Spa. And there's a few items to review here. First and foremost, I personally worked with Carrie, who was on the call earlier. And if you notice, there was an initial amount that came out through the audit. And we had that discussion and it was a fair process. And that included additional charges on things which were internet fees, but those are actually in meetings. And there was a sales tax charge on those, and that's why that did not fall into rent, and that had nothing to do with occupying rooms. And we all agreed on it, and that's why you see that the number came down. So the point we're talking about now is actually attrition. So attrition is different than cancellation fees. Attrition is liquidated damages from a breach of a contract. So when a group books a group with us and they don't meet their obligations, there are liquidated damages that are charged for those fees, right? For not living up to their end of the bargain, pretty much, right? And that's a point that I think we can talk about, and I hope that there's a forum to be able to actually discuss that, because what this all comes down to is 2017, we were audited, the same process. We were collecting attrition fees at that time, and they were not included in the findings, in the audit findings. So by everything we knew and understood, we were absolutely following what the city had put forth and the code. As we talked about recently, Measure Y did not change anything there. Measure Y only changed the percentage. And so we're at a point where we don't know when or where attrition got added in. There is something called the VAF, and that is, let me just, what the acronym of that is. It's the Visitor Accommodation Facility, and these are guidelines that were posted on the city's websites that all of us hoteliers, look at to understand when, the guidance for TOT collection, right? And at some point it was added. That form has changed multiple times over the years, and we don't know when or how, and no official communication has been given to us regarding that. So we don't know when that was added. All I know is that in 2017 it wasn't there, and all of a sudden it came out post 2022. It was the recent one we saw. This is a living document, so it changes. And from my questions, when I asked the city if there were, could we see the, differences and changes in the VAF form, we're not able to find those or see those, and then there's definitely has been no communication. So that's mainly the issue, is that we weren't communicated. The other issue I see here is that, as per city code 35-22.2 and California Government Code 53750, they identify what an increase is, okay? And per the city code 35-22.2, the article may be repealed or amended by the city council without a vote of the people, except as required by law and except for tax increases, as that term is defined by Government Code section 53750. So 53750 defines increased when applied to a tax, assessment, or property related fee or charge means a decision by an agency that does either of the following: A, increases any applicable rate used to calculate the tax, assessment, fee, or charge, and B, revises the methodology by which the tax, assessment, fee, or charge is calculated, if that revision results in an increased amount being levied on any person or parcel. And that vote did not happen. I'm not saying that the vote wouldn't have passed. It just, there is no evidence, or it hasn't been shown to me that it was actually done. And I think, to be fair to, all of us hoteliers understand the importance and the value of TOT, and we understand our role in collecting that and ensuring the city's services are maintained. And we believe that, but we also need to be communicated properly. And we're happy to do that. We've made suggestions that we should really have an annual workshop where the city can meet with our finance directors and general managers, and we say, okay, this is clear, this is how we're doing it, instead of going back after a period and doing an audit, and then saying that the definition has changed somewhere but not according to code. And that's where we really have the issue. And we would like the communication to improve and find a way to work more closely with the city. But that's where we are, and I hope you can understand where I'm coming from. Board Member Milich, I think your questions were exactly where we had some of the confusion. Is when was it changed? We don't know, and we weren't officially notified of it. So that's where we stand, and I appreciate your time.
Okay, we asked you some questions.
Absolutely.
I'll have a couple of quick ones. and then I'll leave it to the lawyers to really get into the meat of this stuff.
Oh, no.
I never thought coming out of my mouth, I would say, leave it to lawyers. Sorry. So you mentioned 2017 an audit, and how now we're in 2023, and you said in 2017 attrition was not included. In 2023 it was. Have there been no audits for you between 2017 and 2017?
17 and then the most recent one were the two audits that we've had.
Okay, thank you.
Mhm.
I had another one, and it's just escaped me. Why don't you pass?
we'll
Come back to me.
Justin?
I mean, the essence of your claim is procedural defect. I get that much. I want to clarify something here. You're saying 2017, you guys were audited? And then cancellation fees, or however you want to characterize it, they were not included in the
Patricia,
2017.
to be clear, we are collecting TOT on cancellation fees, which we consider as an individual who cancels their reservation.
So just to,
Mhm.
so you're talking about like a group cancellation?
We're talking about group, yes, a group. It's more attrition. It's not entire cancellation. Yeah,
I got you.
Mhm.
Like, but they were not taxing that. in 17.
was not brought up in the previous audit.
And that's the heart of your claim right there, right?
That's the heart of the claim.
My other question was, Justin, is that okay if I just jump
Please.
in? Because I think it's
Knock it
pretty,
out, yeah.
and maybe the city could jump in. I have to say, I still don't totally understand the difference between attrition and cancellation. Can someone explain that to me?
I mean, this,
I
City-
still
like-
don't understand the difference between the two.
Just procedurally, should we let them finish their presentation and then the city can?
He's got a question. He's finished. I think he's finished his presentation, which is why we're.
Yeah, we may
I
have more
think he
questions.
could answer the question. It's their, yes, that is what they're arguing. So,
but
go ahead.
I think the crux of what I'm talking about is procedural. I think you hit on it. However, the difference, like I was saying, is that an individual who cancels a reservation individually, we do collect on that and we do pay those taxes. That happens regularly. It is when there is a group contract and they say they're going to take a certain amount of rooms and they're going to provide a certain amount of revenue and they don't. And then there is there are liquidated damages between what they assured us and they promised us, and we collect. We base our liquidated damages on the difference in that contract, and that's what we
Deposit is what they make. They
I'm
make a
sorry.
deposit.
make a deposit. No,
Yeah, deposit to hold the room.
there are deposits that they do give us. We don't always get 100% deposit from them. So we will sometimes we will have to send them an invoice for attrition fees if they don't meet their obligations.
I still don't understand the difference.
But my understanding is, yeah, please, if you can help clarify this. Thank you.
Let's say you have a group and they're staying with you for
And
3
who
nights.
who are you,
And,
please?
and I'm John Turner. I'm the general manager of the Intercontinental, the
Thank you.
Climate. So let's say you have a group and they're scheduled to be here Monday night, Tuesday night, Wednesday night, and their scheduled or contracted pickup is 100 rooms a night, so 300 room nights. Let's say the first night they pick up 75, the second night they pick up 100, the third night they pick up 75. So it's really the attrition. It's that they underachieved.
Got it.
They did not pick up the amount that they were contractually obligated to pick up.
You've totally clarified
And
it
we
for me.
couldn't resell those rooms because we literally didn't know until literally the day of or the day before that they weren't going to be there.
Thank you.
Thank you.
No, I mean, any further questions? I mean, that states it clearly. It does, also go on to food and beverage fees and things like that, because they do have to provide food and beverage minimums when they book a group. So there are some additional, obligations that they have.
So just to make sure I got what you said, John, you hit them with a bill for a sales shortfall? Is that kind of?
Yes.
Okay.
Yes, you're right.
And then the argument is that's not a cancellation fee? That's what you guys are arguing here?
I think that we have, I would hope we could have the discussion regarding that. However, it wasn't in 2017
Okay.
and now it is, and that's where we don't understand where that gap is.
Okay.
So that's the essence of what we're
I understand.
saying. Mhm.
Any further questions from the,
I don't have questions for Craig, but I have questions for the city side.
you have a question for?
For
the city side? Go ahead.
Yeah.
You should keep your microphone on and sorry, I don't think we should be having sidebars.
No.
It's public, but I hear you. Yeah. Can we ask questions of Rafaela? Is this procedurally
If-
the right time or?
Is the appellant done presenting its case? Did you have any other
I have no other.
witnesses you wanted to present testimony from?
No.
Okay, then,
You want to have any cross-examine?
no, but we would like to have a rebuttal to address
that-
some of those
that's-
points,
yeah.
and then maybe after that could
That's
take
fine.
some questions.
It's
mhm.
coming up.
And then we do need to open up for public comment too.
Yeah. Thank you.
Thank you.
Thanks.
You want to put one in the record first? Well, we're going to have public comment first of all. Do we have any public comment at all from?
Do we have anyone in the chambers who would like to make a comment? We do have 2 people online. Okay, sir, did you want to make a public comment?
Yes.
We do online first.
Online first. This is for A. Balthazar. You have 3 minutes. Go ahead. Hello, can you hear me?
I can. Did you unmute me? I didn't ask to make a comment. No, I'm just watching.
Oh,
Okay.
do we have anyone?
The other
else?
public comment is Janine Chickarot. Are you wanting to speak right now?
No, other than the, observation that the city's also had quite a few different finance directors over the last several years, which I think also that lack of continuity has caused some challenges in terms of communication.
Okay, I believe that covers public comments.
We have Members of the public? Kindly state your name and
Good morning. My name is Mike Zimmerman. I'm with the Cannery Road Company. Over the past year, I have been highly critical of this audit process. It has been nothing short of a real mess. A ton of mistakes have been made. My assistant and I have spent literally hundreds of hours correcting and cleaning up these audit problems. We had real issues with what was subject to audit and how that had been communicated over the years. And the biggest issue was parking. And we worked with city council to resolve that issue, where we agreed upon a date going forward. We didn't look back, we worked going forward. And an alternative for resolving this issue should be a look forward. Let's put things in the past. Communication on what is subject to tax has been kind of evolving. It's become more aggressive over the time. It's as Chris spoke. In 2017, they weren't taxing cancellation and attrition. They are now. If you look at the VAF guidelines from 2017, there's nothing listed. The first time we can find cancellation and attrition mentioned is in April of 22, which it would only include a portion of this audit period, not the entire audit period. I think there's a good solution going forward. I think the model of how we handle parking would be a good solution going forward. And I think that's the right answer.
thank you. Is there anyone else from the public who would like to make a comment on this matter? Okay, seeing none, we'll close the public comments and rebuttal.
Thank you, board members. I'd like to go back to the definition of occupancy, which was enacted by the voters in the city of Monterey prior to the date of the current audit period. And again, it charges TOT based on occupancy, which it defines as including the right to the use or possession of any room. So in this case, if you have a group booking and they've booked 100 rooms, they've obligated themselves to pay that, and that's 100 rooms that they then have the right to the use or possession of. As they said, well, okay, we find out the day before and we can't resell those rooms. As that indicates, that group had the right to the use or possession of those 100 rooms. They pay a fee on it. call it a cancellation fee, call it a liquidated damages fee. It was tied to the right to the use or possession of that room. Now, the voters of Monterey enacted that definition before 2020. I don't know what the audit did in 2017, to be frank. But if staff made a mistake or the city auditor made a mistake, they're human beings and that happens. But they do not have the ability to forever waive by that mistake the ability of the city to properly collect based on a definition enacted by the voters, this tax. So the fact that whatever was done in 2020 is really immaterial because a staff mistake doesn't change the law. This is the law in the city of Monterey, the right to the use or possession of the room. So I understand that the Department of Finance, the Finance Department has issued guidelines, TOT guidelines. At the bottom of that, it notifies people that, you know, they need to, my understanding is that they have to, subject to change and should seek guidance from the Finance Department. Yeah. And that is publicly available on the city's website. It's true, those aren't sent out individually. We don't hand deliver each notification, but it's always been publicly available. Finally, I want to address that there has not been a tax increase, as they mentioned. You know, they spend a long time talking about the government code. That's completely a red herring. Here we have a definition enacted by the voters of Monterey. They properly enacted the increase from 10 to 12%. So this has been in the code the whole time. It was voted on by the voters. It would, you know, staff is applying that, the plain language, and that's why we're here today. So we're happy to answer any questions you have.
Corinne, aren't they arguing methodology, not necessarily increase?
Well, I think when he was quoting the government code section, he was arguing that our change amounted to an increase.
Because of the change in methodology and calculation. So not necessarily a nominal increase in the percentage, but you guys are saying that there's a form, they got to come and talk to you to find out what the taxes are going to be? Is that what you're saying? Like you're saying that?
No, they were talking about the guidelines that, you know, sort of like, I would call it an FAQ. If you want to find out, you can go on the IRS when you file your taxes, your personal income taxes. And there are some, you know, how to properly take a deduction for, you know, you're dropping off things at Goodwill. They have things that walk you through that. Guidelines, guidance. But you don't go to the IRS and argue that changed the Internal Revenue Code. That's just an FAQ. That's all that is on the city's website. It doesn't change the city code we're talking to here today. So that was the point I was trying to make there.
So what you're really saying is that failure to collect what could have been collected is sort of a windfall. And now that's being addressed, so it's no longer a windfall.
Correct.
Okay. I just want to make sure I understand you.
I appreciate you succinctly rephrasing that.
Well, I have to. I can't think.
Any other questions?
Yeah. So I'm still just working on my own little brain and what I'm totally understanding about all of this stuff. And so I'm still on what the plaintiff has written on page 6, which is we dispute that the TOT and CCFD tax are applicable to group attrition fees as they are liquidated damage from shortfalls and contractual obligations. And we've had a conversation that there is a difference, or at least a definitional difference, which the good man helped me understand very, very clearly, that there is a cancellation fee and attrition fee. And at least from the practice of from the hotel, those things are importantly different. And the argument is that so here's my question. Sorry. So I know there's a lot of other procedural stuff here that my lawyer friends can get more deeply into than I can. The amount that, at this point where we are right now, the amount that, the plaintiff has been asked to pay, which is, I get, 50,000 or something like that, down from 80,000. I'm just
Roughly
roughing it. I'm just
56,000.
roughing it up.
Mhm.
That 56,000, is it entirely attributable to this dispute or this definitional dispute over attribution versus cancellation?
Let me have Carrie answer that question.
No, the entire amount is not all attrition. The other items that were included in that deficiency were some of the communications, resort fees, mini bar fees. There were some other fees that were included as well.
So is maybe it's another, I have a question for the plaintiff now, or maybe the city can do it. So is what is being requested entire relief from the 56,000, or just the portion of the 56,000 that's related to this question of attrition versus cancellation?
Well, they appealed the entire amount.
They did appeal the entire amount.
Yes.
Okay. Thanks. I probably should have seen that.
And I'll also say that, and Carrie, feel free to correct me if I'm wrong. I believe attrition is by far the biggest piece of that puzzle. Mhm.
You can have the appellant.
Yeah, you have your rebuttal time. Yeah.
No, absolutely. It's attrition. I mean, so first of all, resort fees, we only had for 1 month at the beginning of the audit period that we're talking about, and we did collect DOT, so that was not in there. We are only disputing the attrition because it wasn't defined before. So there may have been a few other fees in regards to some other amenities, I think, that Carrie did find, and we are not disputing those. And we could break those out. I'd be happy to. We're only talking about the attrition because it was not on 17 and now it is. That's
Do you know out of the 56,000 how much is
it's
attrition?
minimal. I can find out, but it's minimal.
The attrition portion?
Attrition is a majority of it. Is a majority of it.
Okay, thank you. I don't need to know the exact numbers. Thank you.
Question, any question? Yeah, any questions? Would the appellant like to make a presentation and rebuttal to what was previously said? Not restating your original case, but responding to what
Yeah.
was presented by.
The only thing and when we talk about it is whatever mistakes were made, which is what she's saying in that 2017 audit, that's what we have to go on. That's what I give direction to my finance team. That's how we set up our systems. This is what we need to do. I can assure you, I don't have the team to daily monitor this VAF form and look for any word that has changed. I think it is the city's responsibility to simply send out a proper communication to us to let us know that this is changing or this is changing. And that's all we're asking for.
If the city were to let you know and let you off the hook for 2020, would you dispute future charges of the same kind in the next audit, the next time around?
I think we would.
That may not be a fair question.
Right. I think I would like to have that conversation. And then once it's settled, we say, okay, then we're starting now. We will start,
I think
charging.
that's right. That's reasonable.
Yeah,
Thank you.
we would make that
Any
reasonable.
questions?
I'm having some issue with the penalty that's being tacked on top. So let's say that we determine that, however we're characterizing the fee should be collected or is within the city's ambit to collect. It seems as though charging them that 10% penalty for something that wasn't disclosed seems a little harsh. I don't know. Do you guys have any statement about that, Karen?
Sure. So in Monterey City Code Section
I
3516,
know it's allowed. It's
yeah, it's a mandatory. It shall invoice the operator for the amount of the net deficiency plus a 10% penalty. So it's mandatory penalty.
there's a due process issue that arises from that. Smells bad.
Well, I mean, legally, staff did not have the ability to reduce that penalty amount.
Okay, is that it?
Actually, Karen, can I ask one more?
Sure.
Normal rules of evidence don't apply.
Mhm.
So, no, sorry. So I'm curious, let's hypothesize that there was some, I'm playing a thought experiment here, right? That's all I'm doing. So in 2017, let's play a thought experiment that, yeah, attrition wasn't actually included.
In that audit.
Yeah, but this is just a my thought experiment. And I guess my question now is we have this audit where it has been included and it's being disputed. I'm curious whether other audits have been done in 2023 of other venues and the same issue has come up.
So my understanding is that the finance department and HDL have been systematically auditing every hotel in the city. And I think we're on round 3 now, 5. Okay. So this is our first appeal before you. You know, there have been many other hotels that have just paid the amount. Now, I don't know, maybe the finance director can speak to whether those included attrition fees, or maybe Carrie can. I don't know.
Yes, we did have some other audits that did include attrition as well in their findings.
And they weren't disputed, obviously, otherwise we would have heard it before.
Right.
Okay, thank you.
That it? Yeah.
The other, there are a couple others, and they are waiting to hear what the outcome of this is. And I was simply the first one to put it forward. We've had our meetings and they agree with our position and they were waiting to hear the outcome of this.
Thank you, that's helpful.
Well, I mean, I will say many hotels have paid without, so it's not like what he said doesn't negate the fact that.
If I could help provide some input maybe on how to frame the discussion and narrow the scope. It doesn't seem that the 2017 audit or process or the way the city code was written in 2017 is pertinent to this appeal today. The ordinance was amended by the voters by the election, and it did change the definition of rent. And in part, it implemented how rent had been interpreted by the city previously, but it also expanded that definition. And so it's not clear to me how the argument is being made that that was confusing or it's been a secret increase with this deficiency charge. Other legal principles you might want to keep in mind is that you're imputed with knowledge of the law. So if you get away with parking in a 20-minute parking zone multiple times and don't get a ticket, and then one day you do get a ticket, it's hard to say, well, you know, in 2017, I didn't get a ticket, so now I shouldn't either. And the public policy behind this tax is that this is not the hotel's money. So think of it in terms of that. This is the visitors, the room renters that pay this sum of money. This isn't coming out of the hotel's pocket. This is collected in trust for the city of Monterey and then remitted to us. And I just think those are important principles to keep in mind as you deliberate this.
This is absolutely, because it wasn't communicated, it was not collected. So this will be absolutely coming out of the hotel's pocket. So because we didn't have the right direction, we did not collect it at the time. We cannot go back to all these groups and take it back now, just so you know.
Any other questions from the board? No, we'll bring it back.
Well,
Please step forward.
identify.
Good morning, everyone. I'm Yusuf Hanala. I'm a finance manager with the city overseeing the revenue division. So for the form, you know, the VF guidelines that the gentleman were referring to, the first line, you know, on the VF guidelines, it says this is a supplemental guide for implementation of the city's uniform transient occupancy tax. And on the second page, so this is just a guideline. And as far as I've been working with the city for the past 15 months, this form probably has changed once. And we add to it, when we get an email from one of the hotels asking for what is included and what is not. So we, or the city, have created this form as a guide to the other hotels where, it would be beneficial for them. And on the second page of this form, as Karen, mentioned, this is just like an FAQ for the hotels. It says, sorry, I'm bringing this. It says, please see the list below for examples of specific items. And if you have further questions about whether charges are subject to taxes or assessment, please call the finance department at 831, our phone number. Just wanted, to point out.
Thank you.
Thank you. Mhm.
That it? Bring the matter, close the discussion, bring the matter back to the board for discussion. Jason, Justin?
This isn't a new issue. It's happening everywhere. It's the idea that administrative bodies, they have a lot of authority. And the city likely has the authority to implement this tax the way that they've stated. The issue that everyone's having all over the country is the idea of legislating by penalty, is that parties don't know what they have to pay until they get penalized and fined. It's happening everywhere. That's primarily the issue that I'd want to raise and discuss, but
We could ask the city attorney, do we have the authority to waive the penalty?
Staff does not have the authority to waive the penalty. I'm just going to check and see if this board can. I believe you can evaluate this audit and take those things into consideration and potentially do that, but let me just double check.
also there's the difference between the fees that are enumerated within the rental section and then a sort of interpretive, something you have to interpret. For a layperson, that's going to be complicated. So that's another piece.
Yeah.
For me at this point, I still have this, or I have the question. There's the legality of it, and all of the verbiage. And then there remains in my mind the practical question of, I know, Christine, you said you don't know why, or you suggested that going back to 2017 is not a good way of doing this. However, there's the law as it's written, or all the language, and then I'm thinking about if it is actually possible that in 2021, 2020, that the exact same language was applied by the city to not actually collect attrition, and then they started doing it because they read their own language and their own rules and so on and so forth, and said, wow, this is kind of, they didn't say this. What I'm ruminating on, you guys, is if there actually has been a practice over the last few years of not collecting this thing called attrition, and then even though it was legally okay to start doing it, there's something about that that just doesn't sit right with me. It seems it's not like changing the goalposts. They're not changing the goalposts, but there's possibly this different interpretation over the years that de facto creates a really confusing situation, I believe. And gosh, if I had my druthers, I'd have as part of this conversation the results of audits and what's not and hasn't been included for the last period of time, and not just one, right? So I am worried about the change in practice underneath the same law, and I still have a question about that, whether that's true or not.
I don't want to disrupt your deliberation, but you can change the amount, or decrease the penalties is the way you phrased it, I think. Yes, you have that authority.
Ideally, we'd be able to say, okay, from now on, you have to pay, but now you don't have to for 2020. However, it's clear to me that my questions were designed to whether or not this was a legal thing to do. And I think it's clear that yes, it is a legal thing to do. And I think what happened is that the hotels got a windfall because staff didn't collect what it could have collected.
But we don't even know that.
Well, I think we had an admission of that.
Okay, sorry.
But
No, because the ordinance requires it to be collected from the guest. They didn't collect it from the guest.
beg pardon?
TOT is collected from the guest, right? And they didn't collect it from the guest, or
Well, they didn't collect it from.
because
The attrition they did not collect.
And so if they knew that it was subject to TOT, they would have tacked on 12%. And they did not, thus no windfall.
They would have added the
Yeah.
12%.
They would have added.
Well, it's a windfall in that they didn't have to pay the tax.
I
There-
believe the code does say that even if it's not collected, it is to be paid. But I'll check.
Right, but what the appellant is arguing on this is, had we known that this thing called attrition was subject to the tax, we would have taken that money from those groups,
Yeah, which they did.
just like we do with our cancellations.
You're right.
And because we didn't think the attrition was applicable to this, we didn't collect the money. And so this is part of their argument to say this. I mean, if we had known that it was attrition, we would have collected the darn money, but we didn't know that it was.
But the legitimacy is based upon the right to possession in 3510 and the definitions.
Mhm.
Where the city, transit tax applies to possession and right to possession. So the people who were attritioned, all right, they had the right to possession, but they didn't show up. So yeah, it doesn't seem fair in a way that you should be taxed on people who didn't show up when you didn't really get the money.
Again, personally, the fact that this, as per the law, attrition should be taxed. I don't have any disagreement with that. What I have a disagreement with, or a question about, what I'm wondering about is, our clients out there in the hospitality industry, they collect the cancellation fees because they know that they're going to get taxed on it, and they take it from the people who have hired that room. It's not coming out of their profits, so to speak. And what I'm understanding here as it relates to attrition, that's not what we're talking about. It isn't like they collected the tax and they don't want to pay it.
Right,
They literally didn't collect the tax because they didn't think it was taxable.
right.
I feel like there's a lot of confusion here. I mean, I don't mean amongst us.
Yeah.
I mean, in terms of the application of
Well,
how this has been
was
done.
this a change in methodology in 2020 to all of a sudden tax attrition when it wasn't taxed before?
Well, that was my question about it. It was so cool to be able to see, previous audits other than just this one, to see whether it has been. And I mean, it's
Well,
just,
The fact that, yeah.
the burden of proof in this case is upon the city. The degree of proof is by a preponderance of the evidence, which is just slightly more than not. So the question is, in your own mind, do you think the city has sustained the burden of proof? That more likely than not that this money is owed. That money is owed based upon the code section.
I think the city has proven that the money is owed as long as everybody truly understood, and in point of fact and in reality, everybody understood what the tax structure was. If that's the case, the city has proven that, hey.
I think haven't we proved that in this hearing that nobody knew what the heck was going on?
I think that there was a lot of confusion here, and I do agree that there was at least some kind of substantial miscommunication. And it feels punitive to me given what I feel is a lot of miscommunication on this. I'm leaning towards something like forgiveness for that attribution for this year. With moving forward, we all know now that that attribution fee actually is what's going on here.
I don't think we can do that.
We can do that.
We can waive the penalty.
What can we do?
It's very broad, the way it's written. And so the whole purpose of having an appeal is that you have
Right.
the ability to change course.
It's not a court of law.
Mhm.
So we can sort of craft our own.
I think you can, but I'd be cautious that we make it really clear so that we know how to apply this board's interpretation going forward and what your objective is. So
So we could say prospectively in the future, attrition is included.
yes, I mean, I think what the board is saying is that it's always been included and was lawfully able to be charged. And I think you're finding maybe other reasons why in this particular case, and maybe this particular case only, it should be adjusted or waived or penalties reduced or something of that nature.
I would.
Again, I want to really, really be clear. I have zero qualms about implementation of this in the future as it's been described. Zero. I'm just worried that it hasn't been equally applied in the past, perhaps, and I don't have evidence that it hasn't been, nor that it has. And based on the public comments and based on what the plaintiff said about this, I feel that the presentation, I believe it. It felt factual, and so that's where I'm landing on this right now. Me as the non-lawyer.
No, I think the city wins on legal substance, but there's an equitable and procedural issue that really can't be ignored. I don't think we should penalize them. I don't think they should pay retroactively, but it should be known that prospectively that they will be paying, and adding that 12 points on top of attrition or whatever we're calling it, because the city's making it clear that's how they're interpreting the occupancy.
Want to make a motion out of that?
You okay with that?
Sure.
If I could ask our finance director just to give us the proper schedule of how this is collected, so we can make it really definitive in the order. So if it sounds like the board is interested in not charging for attrition, but you are saying it's a lawfully to be charged, but you're finding equitable or other reasons why not to charge it in this particular case. Okay, and so then when would that time period apply? I guess is what I'm asking the finance director.
Right, we do need to know when, because we do have, even though we're just starting phase 5 of the audits, we just completed phase 4. So if there's if you're saying that for attrition moving forward, starting today or whatever day that is, that we're not charging, we need to know that, because we'll have to go back and amend all the audit reports that we've done moving forward. So we just need to know when that cutoff date would be.
Christine, do you have a recommendation? You're our lawyer.
I can't recommend on the policy. Just
No,
on
no, I
the-
know. I'm talking
yeah.
about the period, specifically that.
I think I would just have a couple more questions. So for the last cycle billing period, like when would the next remittance be of transient occupancy tax?
I believe we can collect the taxes on the 15th day of the following month. We
And it's
collect
monthly now, right?
It is monthly.
And do we know if it's been collected with respect to this appellant since the date of the audit notice? Like, for example, did you start collecting it at a certain point? Once you were put on notice that this is what?
Yeah, the form that we use doesn't specify, so we don't know.
Okay, but once the city sent the appellant the notice of the amount due and it had on their attrition, and then they're saying, well, we didn't think we had to pay that. Was there a time from that notice that it was started to be collected.
We
Yeah.
wouldn't know that from the
Okay,
forms.
okay.
We would just know whatever calculations that they.
Okay,
Yes, so we already did start. However, I think it to be fair to all of the other, this hearing will give direction to all of the other properties. So I really feel the first month of April going forward, RTOT would give fair notice to all hotels and we could get that out and they would understand that it would be down taxable.
well, what I'm trying to get at is when did your hotel start
I don't know
submitting
the
it?
exact date, but it's been several months.
I think it's reasonable to assume that from the date of the audit letter is
Yeah.
received and it's been charged, that you should be charging it at that part going forward. Most definitely, yeah. Mm-hmm.
So the audit letter was, the initial one went out in December and then the revised one went out in January.
Yes.
Can I help? I've been really involved with these. I think the stuff on-
Well, I'm sorry, so the board would have to reopen public comment if you're gonna,
Yeah, reopen public comments, please.
okay.
Thank you.
Mhm.
So I think it should be pretty clear. Anything that's been collected from a guest gets remitted to the city, regardless of whatever date you pick. If somebody had been collecting 6 months ago, they pay it. And then have a date going forward that you apply penalties if it's not collected and that it's due. You could do an April 1st date. You could, that's an easy date to go forward. Everybody's got notice of it. But it's real clear that whatever anybody collected, you pay. If you've been collecting it on we did that on parking. Whatever somebody collected, some started collecting before the date that it applied, you pay it, you owe it. You don't get to keep those trust funds.
So if I could just, I'm not familiar with what happened with parking. I don't recall there being any sort of appeal hearing board decision on parking or city council action on parking.
It was city
was-
council
it was-
session.
Okay. Oh, okay. All right, so
So in that,
If,
Would I-
can the department respond to this public comment?
yes, I just have another point though to make, which is I want to stay, I think, away from this delineation of whether it was paid or not paid, because the code requires the hotel to pay it, whether or not it's paid by the transient. So I don't want to start having a different rule developed here today for that. If we're just trying to narrow down what might be a fair period of time in the board's mind for prospectively charging this amount and,
So is this necessarily the right forum for this? This seems more, right,
Mhm.
like this should be something that's negotiated between the city.
Well,
Could I?
Yeah.
I think it's only fair that the department get a chance to respond to that
yes.
public comment. And if I could say, we heard testimony today that the guidelines, which the board clearly thought was important in terms of the procedural notice to the parties, that those were updated in 2022 to include cancellation and attrition fees, and it's now 2024. So this idea of no notice, it is just that we would start charging it in April 2024. I don't think it's fair to the taxpayers of Monterey.
Okay.
And I just want to make that clear for the record.
Okay, Hans wants to-
So, thank you. My thinking is, in front of you is just the appeal. So
Hmm.
my suggestion is, just deal with the appeal, right? Don't worry about the rest. We'll have to figure that one out ourselves.
That's true. I mean, this is the only matter that's before you today.
All right.
Mhm. Could you, I'm sorry, we should just make sure there's nobody online that has wanted to
Open public
give
comment.
public comment.
There is someone online. Let me see if they want to make a comment.
No, thank you.
Okay, thank you. Then at this time, we have no one.
Okay, then we'll
Okay.
Close public comment.
Right, so in other words, we would, the decision we'd be making right now is we agree with the appeal. Nothing else from moving on, the city's gonna have to figure this out with, that's the only thing
Right.
we would be deciding.
That's correct.
Right.
And so the draft decision, for example, that the board always I'm sorry, the city always, we're not accepting that.
Right.
We're accepting what the plaintiff has said, but anything moving forward on this is beyond our purview.
And the discussion that we have here is advisory, is essentially, because we're ruling on the appeal. But the information that we set forth in terms of what we think should happen is to be taken into consideration by the city when they're crafting their policy, hopefully in negotiation with the parties.
Right. What I was trying to nail down is, well, first, I guess we need to know what the board wants to do. Are you just waiving penalty? Are you granting the appeal 100%? Are you granting the appeal 50%? And is there any timeline to which that applies just to this appellant, not for the whole round 5 of audits?
But there's no motion on the floor. so-
Okay. I just need to make sure I can draft findings that reflect your intention.
Let me just say, I'd be in favor of granting the whole thing.
You'd be in favor of what? I didn't hear you.
I'd be in favor of waiving the whole thing.
Waiving the entire 56,000?
Yes.
I'd only want to waive attrition.
Well, okay,
I would only want to waive the attrition
I'll go with
and approve that
I'll go with that.
as what we are deciding right now.
We have a motion. on the-
And
No, I'm the chair, you make. the motion.
I just want to make sure again, I mean, Christine, if that's what we are thinking of deciding, that is the only thing that we're deciding. We are not deciding in the future, when does this start being paid? That is not what we're doing.
No.
I was just wondering if if there was a period of time that this hotel was on notice that it should be paying it, and have they started paying? But I think it's outside of the appeal period, so,
That's what I think.
right, yeah.
So I'll thank you for all this thanks for all the help, everybody. It's been from the city side and from everybody. It's just been really helpful. Thank you. So I move that we waive the portion of the $56,000 or so that is attrition fees. And that's my motion.
The penalty?
There shouldn't be a penalty on the attrition fee since we're waiving it. The other fees that are in there, yeah,
Okay, so it's the attrition fees.
yeah. If you're waiving the attrition fees, you can't be paying a penalty on them.
Well, but it's not all.
No, I
attrition
know, that's what I'm
fees. You
saying.
want the penalty paid on the rest of.
On the rest of it, sure,
Right.
sure.
Second,
Second,
all right.
Okay, we'll have a roll call vote. Board Member Chang,
yes.
Board Member Milich,
Yes.
and Board Member Glanzer.
Yes.
Okay, let the record reflect the motion is passed 3-0.
It's like watching sausage being made. Thank you. With that, any comments from the members of the board?
No comments.
No comment? Okay, well, with that, let's adjourn.
We're adjourned at 11:24.
Thank you.